Can we start? Good day, dear colleagues, and good morning to some of the participants of this forum. Let me welcome you on behalf of the Constitutional Court of Kazakhstan and express my gratitude for your participation in this forum. This event is being held within the framework of the joint program of strategic partners of Kazakhstan and the European Union, as well as the Council of Europe in the rule of law for Central Asia. The forum is organized by the Constitutional Council of the Republic of Kazakhstan, together with the Venice Commission of the Council of Europe, which is the recognized expert in the issues of constitutional justice. Our event brings together the representatives of the constitutional control bodies of Uzbekistan, Tajikistan, Kyrgyzstan, foreign experts representing the European Union, Venice Commission, and other international organizations. Among us, there are the members of parliament, judges of the Supreme Court, the senior officials of the President's Office, General Prosecutor's Office, Ministry of Justice, and the academic community of Kazakhstan. The higher educational institutions of the legal profile and other experts are joining us through YouTube. The meeting today is devoted to a very relevant problem, the execution of the decisions of the bodies of constitutional control or courts. Dear participants of this seminar, as you know, in any democratic and legal country, the constitution is main regulator of the system of socio-economic and political, as well as other relations. And the work of the constitutional justice bodies are aimed at ensuring the rule of law, and this mission predefines the spirit of the constitutional courts, which are the continuation of constitution and have the highest legal force. In such decisions, the defects of the legal regulation are identified, and the special value is attached to the legal positions formulated in them. In terms of exclusive authorities on the check of the constitutionality of normative and legal acts, our constitutional bodies provide the interpretation to the norms of constitution and the current provisions of our legislation. In this regard, in the global practice, we frequently deal with this concept of constitutional and legal spirit of the law. This year, in its conclusion on Kazakhstan, the Venice Commission emphasized the importance of argumentation of the constitutional bodies, which, in its opinion, needs to serve as a guideline for general courts and other government bodies. The Commission paid a special attention to the fact that the legal force of the decisions of the constitutional review bodies cannot depend on whether or not the subsequent actions will be undertaken by certain subjects, including Parliament. In some countries, there is the mechanism of further improvement of legislation that includes the subjects, duration, and the order of submitting the draft laws, as well as responsibility for non-implementation. In theory and in practice, there are different mechanisms and instruments aimed at maintaining the legal certainty in legal field, in legal relations. And among them, there is the possibility of settling down of the way of enforcing its decision without retrospective effect, and etc. And the Constitutional Council of Kazakhstan right now has developed specific proposals to make amendments to the legislation that touch upon the order of execution of the decisions, and my colleague will touch upon it a little bit later. These and other issues are common for us, And that is why they are considered as the subject of the discussions of the current seminar. And I'm sure that this seminar will make it possible for us to exchange our opinions and develop some optimal solutions to existing problems. Let me declare our meeting open and switch to welcoming remarks. Dear colleagues, this seminar has become possible thanks to the support of the Venice Commission and personally its president, Mr. Gianni Buchicchio. Please, Mr. Buchicchio, the floor is yours.
This is for appeals following an election or appeals as a result of political debates. Even if the Constitutional Court stays well away from political issues, its decisions will inevitably have political consequences. This is part and parcel of democratic life and the unthankful role of these courts. It is a part of the Constitutional Court's authority to see its decision executed. This is also a part of the principle of the rule of law that must be respected. And as painful as it may be, it is for those institutions affected by a Constitutional Court decision to accept and, more importantly, to ensure its execution. This is real democracy. Therefore, the level of acceptance of Constitutional Court decision and their execution reveals the level of democracy in any given country. Should Constitutional Court decisions not be properly implemented or not be taken into account by other institutions or even by courts, then the authority of the Constitutional Court will be challenged, as will the structure and the reality of the rules and rights enshrined in the Constitution. This is a slippery slope and affects the level of real democracy and the protection of human rights in a country, and finally, the confidence of its citizens in the system. The execution of Constitutional Court decisions is therefore an indicator of the effective functioning of democracy, national institutions, and the level of human rights protection afforded in the country. This is why the sign of a real democracy is less a matter of the existence of texts than a matter of their implementation. Ladies and gentlemen, in a real democratic state, there is trust between institutions and respect for their roles. There is respect for Constitutional Court decisions. Their decisions are executed efficiently and without delay. A good and effective execution is essential to maintain and improve the protection of human rights. It also favors good governance and enhances the respect for the rule of law. To this end, dear President of the Constitutional Council, dear friends and participants, I wish you a very fruitful seminar and discussions. Thank you very much for your attention.
Thank you, Mr. Bukikio. Let me thank you for another joint event and your readiness to provide an expert support on this very important topic. Over these years, not only you have become a reliable partner, Mr. Bukikio, but you have become a good friend of Kazakhstan. The leadership of the Republic and the legal community of the country highly appreciate the contribution of the Venice Commission of the Council of Europe and personally your contribution into the strengthening of the rule of law. You were at the outset of creating one big family of the constitutional justices of the world. I wish you every success, and I really hope to see you at our international symposium this year on the 27th of August. I'm sure that your potential will serve the interests of the implementation of the principles of the legal state. Thank you very much for your work, Mr. Bukikio. Next floor goes to the ambassador of the EU to Kazakhstan, Mr. Sven Olof Carlson. Please, the floor is yours. Thank you, Mr. Chairperson, Mami.
Mr. President of the Venice Commission, Mr. Bukikio, distinguished participants, ladies and gentlemen. On behalf of the European Union, I would like to thank the Constitutional Council of the Republic of Kazakhstan, as well as the Venice Commission, for having organized this international seminar today. The European Union is strongly committed to support our colleagues from the Central Asian countries in their endeavors to further improve the functioning of state institutions. To follow up on this commitment, the European Union decided to support a comprehensive Central Asia rule of law program. And to implement this program, we joined our forces with the Council of Europe, one of our most experienced and trustworthy partners. Since its launch in early 2020, the ambition of this initiative has been to provide support and to assist the ongoing democratic reforms in Central Asia, taking into account very specific needs and demands of each country. Through this program, we have been facilitating open discussions, exchange of ideas and best practices between renowned experts and experienced practitioners of Central Asia and Europe on a wide range of issues, representing common values and shared goals. In February this year, we organized a virtual meeting to discuss the referral of the decisions to the Constitutional Council of the country by ordinary courts. Based on the discussions at that meeting, and at the request of the President of the Council, Mr. Mami, the Venice Commission adopted the concept paper on the improvement of the legal framework of the Constitutional Council of Kazakhstan. Today, I hope we will be making further progress. The goal of our meeting today is to encourage and support our Central Asian partners in the process of strengthening the mechanisms of the protection of human rights according to the international standards. The proper and swift execution of the decisions of the constitutional courts, councils, and of other equivalent bodies can significantly improve human rights protection in a given country. But not only. It can also promote good governance based on the respect of the essential principles of the rule of law, and strengthen the authority of the constitutional courts and councils, both at national and international levels, as the major guardians of the democracy and the rule of law in the country. As you know, the Venice Commission is an internationally recognized authority and has a long-standing experience in the matters related to constitutional justice. Using this occasion, I would like also to welcome the 4 experts from Bulgaria, Czechia, the Republic of Moldova, and Georgia, who are joining our meeting today. I'm looking very much forward to listening to their presentations and to follow our discussions later today. Thank you very much for your attention.
Thank you, Your Excellency Ambassador. I wish you successful implementation of the program of the European Union and the Council of Europe on the rule of law. Distinguished participants, now, according to our agenda, we have our presentations. I will remind you that we have 15 minutes for the presentation by the speakers. We will first listen to our speakers, and then at the end we will have Q&A and discussion. And I would like to give the floor to Kunzila Shapak. Good day, distinguished ladies and gentlemen, colleagues. The topic of my report is the execution of the decisions of the Constitutional Council, questions and perspectives. The current seminar is devoted to relevant topic. Constitutional review is important attribute of the modern democratic constitutional structure of the majority states in the world. Without this, in the modern realities, it is impossible to support constitutional legality and legality in general. Constitutional review ensures functioning of constitution as the fundamental law having direct effect. Without effective constitutional review, the Constitution is doomed to stay no more than the General Declaration of Principles. The main mission of the constitutional control is to ensure the supremacy and stability of the Constitution, keeping constitutional segregation of powers and guaranteeing the protection of constitutionally enshrined human rights and freedoms. The inclusion by the state in its legal system of constitutional review indicates that the state prefers to provide powers on taking the decision about constitutional legal questions to the specialized bodies. Thus, the execution of decisions of the constitutional review bodies is the key prerequisite of ensuring in the country the rule of law principle. It should be mentioned that according to paragraph 1 of Article 4 of the Constitution of the Republic of Kazakhstan, the current law in the Republic of Kazakhstan is the norms of the Constitution, laws compliant with it, and other legal acts, international, contractual, and other commitments of the country, and other legal decrees of the Constitutional Council and the Supreme Court of the country. Constitution has supreme legal force and direct effects on the in the country in general. Chapter 6 of the Constitution of the country includes fundamental norms that establishes constitutional review in the country, the implementation of which is imposed on the Constitutional Council. It is not a part of judiciary system. It is an independent state body that ensures the supremacy of the constitution of the country as the fundamental law on the whole territory of Kazakhstan. The decisions taken by it are aimed in order to serve to the proper interpretation of principles and norms of the constitutions by different entities, subjects of public relations, which is the guarantee for stable and sustainable development of the state. Legal positions of Constitutional Council play important role not only in ensuring constitutionality in the relevant legal relations, but also serve as guidelines in the development of the current legislation and formation of law enforcement practice. The decisions of Constitutional Council come into effect from the day of the adoption. They are mandatory in the country, final, and are not subject to appeal. They are effective guarantor of the fact that the legislation of the country and indirectly, ultimately, the law enforcement practice will not go beyond the constitutional norms. And modern and complete implementation of the legal positions and recommendations of the final decisions of the Constitutional Council on the improvements of the laws and other legal acts, as well as the law enforcement practice, is considered here by us as one of the main requirements for ensuring constitutional legality in the country. The decision of the Constitutional Council are covered by Chapter 5 of the Constitutional Law of 29th of December 1995 about Constitutional Council of the Republic of Kazakhstan. According to this law, any act taken during their decisions taken are divided into final, that are implemented by constitutional powers of Constitutional Council, and other decisions that are implemented by other powers of the Council. The legal nature of final decisions of the Constitutional Council is enshrined in the Constitution of the country and Constitutional Council about Constitutional Council of the Republic of Kazakhstan, and they determine the directness of the execution. Constitution of the country does not define the procedure for the execution of the decision of the Constitutional Council. According to Article 40 of this constitutional law, Constitutional Council can identify the process and the period timeline for the execution of its decision. In 2008, this article was amended. These amendments strengthen the mechanisms for the execution of decisions of the Constitutional Council. Now, the decisions by the Constitutional Council and the recommendations and proposals in these decisions on the improvements of the legislations are subject to mandatory consideration by the authorized state bodies and officials with mandatory notification of the Constitutional Council on this taken decision. About the measures taken in order to execute the decisions of the Constitutional Council, it is informed by the relevant state bodies and officials within the period stated by the Constitutional Council. In case if the decision of the Constitutional Council requires the increase of state expenses or the reduction of state income revenue, then Constitutional Council will identify the time period for the execution of the decisions taken by it upon the approval with the government of the Republic of Kazakhstan. An important direction of the work on related to this topic is the adoption of legislative measures. And quite often in the acts of Constitutional Council, an attention is given to the subjects of legislative initiatives to certain aspects of legal regulations that require taking of legislative measures. According to the regulation of the government, formation of the plan for law drafting works of the government for upcoming year is done with account of legal decrees and annual addresses by the Constitutional Council. In the practices, there are examples of approval by the governments of the country of the comprehensive plan of actions on bringing the current law system in compliance with the constitutional norm. For example, 2008. It envisaged the measures aimed at execution of normative decrees of the Constitutional Council, as well as its proposal and recommendations mentioned in the annual addresses on the status of constitutional legality in the country. According to the rules, organizations of law drafting work in the authorized bodies of the country prepare the draft law according with account of the provisions of annual address of Constitutional Council and its normative provisions. There are many examples when adopted law before its signature by the President, it is sent to the Constitutional Council in order to verify for its compliance with the Constitution. If it is recognized as non-compliant with the Constitution, then it cannot be signed and brought into effect until the relevant defects are not fixed according to the legal process. For example, the decree of 27th of March 1998, the Constitutional Council recognized certain norms of special part of civil code as unconstitutional. After this decision by the Constitutional Council, these norms were finalized and readopted by the Parliament, and then civil code was signed and brought into effect. It should be mentioned that over the period of its activity, Constitutional Council adopted more than 145 legal decrees, of them 6 about additional interpretation of its decrees. Analyzing the activity of the Constitutional Council over the past years, it should be mentioned that many decisions were taken that were aimed at the implementation of the potential of the Constitution, that at the same time became catalysts for formation of certain conceptual directions of the modern national constitutional policy. The positive impetus to the implementation of the Constitutional Council decisions is given by the annual discussion of this matter at the meeting of the consultative and advisory body, the Council on the Legal Politics under the President of the Republic of Kazakhstan, with determination of the responsible state bodies and specific instructions. Every year, according to the plan of work of this council, meetings are conducted where information about the execution and about the measures taken in order to implement final decisions of the Constitutional Council are conducted. One of the tasks of the Constitutional Council is to prepare annual addresses about the status of constitutional legality in the country. These documents, Constitutional Council, based on the considered requests, analyzes current legislation and its law enforcement practice from the perspective of their compliance with constitutional norms, and pays attention of the relevant state bodies to available defects, also including in the area of execution of the decisions of the Constitutional Council. We think that the positive impetus to the execution of decisions of the Constitutional Council will be given by the recently adopted changes and amendments to the law of the Republic of Kazakhstan, dated 6th of April 2016, about legal acts that envisages simplified procedure for the preparation of normative and legal acts. This law is amended with new Article 21(1) that envisages that norms of laws and other normative and legal acts that are recognized as unconstitutional and also as the breaching the human rights and freedoms enshrined in the Constitution are cancelled and are not subject to implementation. The draft legal acts developed under simplified process shall contain only those norms that are aimed at the implementation of the decision of the Constitutional Council of the country. State body which competence includes the adoption of the legal act that contains such cancelled norm by the Constitutional Council, can develop and introduce to the government the draft legal act in the simplified process defined by the government. It can be said that the mechanism for the execution of the decision of the Constitutional Council works rather effectively. Over these years, state bodies and officials took a number of legislative, organizational, and other measures aimed at execution of concrete final decisions of Constitutional Council and strengthening legal mechanisms for execution of Constitutional Council's decisions. In this regard, Constitutional Council currently develops proposals on introducing changes and additions to the constitutional law on the Constitutional Council of the Republic of Kazakhstan. Thus, in particular, in order to ensure legal certainty and balance of interests, it is proposed that Article 39 of this constitutional law shall be amended with the norm that envisages that the decisions of law enforcement bodies that are based on unconstitutional law shall not be fulfilled and shall be also subject to the revision according to the established process. However, with account of circumstances of certain request, Constitutional Council isn't, according to the paragraph 1 of Article 40 of the Constitutional Law, is entitled to identify specific procedure for execution of its decision that may imply, in particular, exclusion of the necessity for the revision of earlier taken legal acts. Such process was, for example, used in the normative decree of 21st of January 2020, where Constitutional Council indicated that normative decree, doesn't have retrospective effect. That means that it is not mandatory to revise and cancel earlier taken and enforced judgments about taking people out of their residences. Venice Commission envisages that at least courts can initiate procedures to review verdicts on criminal cases after the cancellation of the norms of criminal law that were served as their basis. It can be envisaged the time limitation for the revision of the final judgments. All this is aimed at keeping legal certainty in already legal relations that already emerged. And besides, we propose to indicate 6 months limit to the introduction of draft law into Majlis, aimed at execution of the decisions by the Constitutional Council. It is related to the execution of legal positions of Constitutional Council that are of mandatory nature. This experience exists in the number of countries and is related not only to the laws but bylaws. For example, in the Russian Federation, if the decision of Constitutional Court recognizes that legal act is not compliant with the Constitution or some gaps should be fixed or controversies, then the government has no less than 6 months in order to introduce to State Duma draft law. This requirement acts when the law or some of its provisions are recognized as compliant with the Constitution and by this Constitutional Court interpretation. And with regard to the low-level legal acts, there are 2 months limits. And these measures are aimed in order to identify specific time frames for the execution of decisions by the constitutional jurisdictions body. In some countries, there is the practice of taking decision about unconstitutionality of the norms of the law. However, with keeping of its effects and identifying the time limit for its legislative correction. And if within this period Parliament doesn't require measures, then the norm loses its legal force. In conclusion, we'd like to mention that constitutional review is an impetus for the ongoing improvement of national legal system and harmonization of the changing public relations. Constitutional review in our country plays serious preventive character that forces state bodies and every member of the society to stick to the legality. Thank you for attention.
Thank you very much, Unzila Shapakovna. I would like to give our next floor to the Chairperson of the Constitutional Court of the Republic of Uzbekistan, Mr. Mirzaulukbek Abdusalomov. Please, the floor is yours. Distinguished Chairperson Mami, distinguished Mr. Bukikio, ladies and gentlemen, first of all, let me express my gratitude to the organizers of this seminar. Can you hear me? Yes, we can. We have a lot of interferences. Could you please put your microphone closer to you? We can hear you, but not really well. First of all, let me express my gratitude to the organizers of this seminar, to the Constitutional Council of the Republic of Kazakhstan and the Venice Commission of the Council of Europe. I was elected as the chairperson of the Constitutional Court of the Republic of Uzbekistan just recently. Are there any interferences? Mr. Mami, can you hear me? We can't hear you. Mr. Abdusalomov, we can hear you. Sometimes we lose you, sometimes we don't hear you, but right now we can hear you. I would like to mention the role of the Venice Commission of the Council of Europe because it provided a great methodological support to the constitutional bodies of Central Asia, ensuring the rule of law and strengthening the constitutional legality of these countries. The regional conferences and workshops organized by the Venice Commission assist the exchange of opinion and experience between the constitutional review bodies, and they facilitate the identification of facts that promote the main areas of human rights protection by implementing the constitutional justice. And the regional seminar that is being held today as part of the rule of law program in Central Asia for 2020-2023 is not an exception. I would like to address Mr. Bukikyo. Mr. Bukikyo, we've met each other in 2018 in Venice, and back then we discussed the draft electoral code of the Republic of Uzbekistan, and I'd like to inform you and say that the law was adopted on the 25th of June of 2019, and it was approbated really well. And in October of this year, on the basis of the new code, we will carry out the presidential elections of the Republic of Uzbekistan. We have a close cooperation with the Constitutional Council of the Republic of Kazakhstan that is being headed by Mr. Mami. And our relations were always productive and mutually beneficial. And our cooperation is being implemented as part of the Association of the Asian Constitutional Courts and equivalent bodies, as well as the Eurasian Association of the Constitutional Review Bodies. Taking advantage of this opportunity, I would like to let you know about the participants of our let you know about the work that is being carried out in Uzbekistan. This work is aimed at improving the constitutional legislation in order to ensure independence and autonomy of the Constitutional Court, in order to ensure its role in reaching the rule of law. At the stage of the development of the constitutional justice, we planned to have drastic changes initiated by the President of Uzbekistan, Shavkat Mirziyoyev, and in accordance with the strategy of the priority areas of our development, in 2007 and 2011 included the reforms in the field of ensuring constitutional justice. The amendments and changes were made to the Constitution of Uzbekistan, and they were aimed at drastic improvement of the work of the judiciary. Particularly, they were aimed at the improvement of the constitutional review. According to the amendments to Article 108 of the Constitution of Uzbekistan, the way of forming constitutional courts was improved, and the Constitutional Court is now elected by the Senate of the Parliament upon the initiation of the President and the higher Judicial Council. So the Constitutional Court is not only formed by Parliament and the head of state, but also by the specialized bodies of the judiciary, or the highest Judicial Council. So under this strategy, just recently, on the 27th of April of 2018, of 2021, the new constitutional law was adopted. This was the law on the Constitutional Court of Uzbekistan. And by the way, this is our second attempt in 4 years to adopt the new law. This law comprises of provisions aimed at democratization of the constitutional justice and proceedings. The law is aimed at increasing the effectiveness of the constitutional review and increasing independence and autonomy of the constitutional courts. The list of subjects of the constitutional review is expanded, and there is an Institute of Constitutional Appeal. If prior to the constitutional reforms this right belonged to 12 subjects only, according to the new law, this right is provided to 15 subjects. And now the right to appeal to the Constitutional Court also belongs to the Deputy Ombudsman for Human Rights and Ombudsman for Children's Rights, National Center for Human Rights, and the Ombudsman for the Protection of Rights and Interests of the Entrepreneurial Subjects, as well as the Ombudsman for the Protection of Rights of Individuals and Legal Entities. The Constitutional Court takes into consideration the appeals of legal entities whose constitutional rights and freedoms were violated. And the court is guided by the specific law of the Republic of Uzbekistan. The expansion of the list of subjects of constitutional review, of course, expands the access to constitutional justice, and it also strengthens the law enforcement functions of the Constitutional Court, one of the most important legal instruments in ensuring this was the establishment of the institute, and the Constitutional Court implements different constitutional proceedings, practices on the basis of this institute, and provides information to both chambers of Majlis and to the President, the information about the condition of the constitutional justice in the country. And according to Article 4, the Constitutional Court of the Republic of Uzbekistan is defined by the law and decrees of both chambers of Parliament, by the decree of the President of Uzbekistan, and by the decree of the government of Uzbekistan, as well as the decisions of the local authorities, intergovernmental and other liabilities of the Republic of Uzbekistan, and the constitutional law on ratification of international agreements, as well as the procedure of signing these agreements. All of these things are considered by the Constitutional Court. The Constitutional Court also takes into account the normative and legal acts that must be applied with regards to specific cases. The Constitutional Court makes decisions on specific normative and legal acts, the constitutionality of which is doubted. The court can also make a decision in favor of some legal acts based on justified acts or which reproduce the provisions of normative and legal acts, even if these provisions have not been mentioned while being considered at the Constitutional Court. The law reinforces the mechanisms of ensuring unconditional implementation of decisions of the Constitutional Courts, and the decisions of the Constitutional Courts cannot be appealed. The normative and legal acts or parts of legal acts which are considered non-compliant with the decision of the Constitutional Court stop being valid, and the government bodies that adopt these legal acts must carry out their review for the period of no more than 1 month based on the decision of the Constitutional Court. The law also says that an order or any kind of act that was adopted by the General Prosecutor's Office and recognized non-constitutional upon the decision of the Constitutional Court stops being valid as well. The legislation of Uzbekistan takes into account some punishment measures for non-execution of the judicial acts. So, according to the Code of Administrative Offenses, and the violation of the non-implementation of the clause on implementation of judicial acts prescribes fines, and there is the Bureau of Mandatory Execution of Acts under the General Prosecutor's Office of Uzbekistan that gets involved in this process. Moreover, the Criminal Code of the Republic of Uzbekistan includes punishment for the evasion from implementation or execution of the judicial acts, and the Constitutional Court can appeal and start the criminal case to attract the guilty persons to the liability for this offense. Thus, the legislation of the Republic of Uzbekistan prescribes the mechanisms to ensure the execution of the decisions of the constitutional courts, which is the great sign of the protection of human rights and freedoms, strengthening of independence and autonomy of the constitutional courts. In conclusion, I would like to once again thank the Venice Commission of the Council of Europe and the Constitutional Council of the Republic of Kazakhstan for the arrangement of this seminar and for this opportunity to exchange our opinions and experience in the fields of constitutional justice. I wish you every success in this seminar. Thank you for your attention.
Thank you. Thank you, Mirzi Ulugбек Elçievich. You have explained a lot about the developments of the new stage of constitutional review and also about the and I would like to congratulate you again with the appointment to the chairman of the Constitutional Court of the Republic of Uzbekistan. I wish you success and also wish you successful international conference that you planned for the 30th of June. I would like to give the floor to the judge of the Constitutional Court of the Kyrgyz Republic, to Mirgul Bobukeva. Please, the floor is yours. Mirgul Raskulbekovna, please, the floor is yours. Thank you. Can you hear me? Yes, we can hear you. Good day, distinguished colleagues, distinguished chairperson, Mr. Kairat Mami. Let me, on behalf of the Constitutional Court of the Kyrgyz Republic and on my behalf, to personally welcome all the participants of this international seminar. I am glad to see people I know, my colleagues from other countries, Gianni Bukikio, Mr. Alexander Tanas, Ms. Shapak, Mr. Malinovsky. I welcome all of you. I hope that all of you are in good shape. Today, we are here online in order to discuss the important topic of the execution of decisions of constitutional courts, both in Central Asia and in Europe. And I'm confident that we will have a fruitful work and we will exchange knowledge, experience related to the topic of this international workshop. We clearly understand that the further gradual development of the constitutional review in the Kyrgyz Republic as the most important elements on the way to the rule of law will be difficult without the study and implementation of the best international experience in this area. Such interest to this topic is caused by the important significance of the decisions of constitutional courts for the constitutionality in the country. Effective execution of the judicial judgments is one of the main elements of the rule of law principle. Distinguished colleagues, before I move to the main topic of this seminar, let me briefly inform you about the events that took place in our country and that impact the development dynamics of the constitutional review body in Kyrgyzstan. In the Kyrgyz Republic, the constitutional reform was conducted, and the results of which, on the 5th of May 2021, a new constitution came into force. At this current stage, with from Parliament and Presidential Republic, Kyrgyzstan was transformed into a presidential republic and supports the building of democratic and legal state. As it is known, specific role in the successful implementation of democratic and legal reforms in the society depends also on the judiciary, including also constitutional review body as a mechanism which is aimed to ensure implementation of tasks and functions of the legal state and also to ensure the supremacy of the constitution. Therefore, the supremacy of the constitution is the first and foremost priority that to guarantee the distribution of powers, rule of law, and development of the truly legal state. Constitutional review body has important task to protect and proper implement the norms of the constitution of the state. Distinguished colleagues, our international seminar is being conducted during specific, unique period for Kyrgyzstan when constitutional review body is at the border state. When Constitutional Chamber of the Supreme Court is transformed into Constitutional Court, when there are changes of institutional and procedural nature happening. According to the new Constitution, Constitutional Chamber of the Supreme Court is transformed into Constitutional Court of the Kyrgyz Republic, and it has new powers, along with the powers that Constitutional Chamber had before, like cases about the compliance of the law and other legal acts of the Kyrgyz Republic with the Constitution, and also this, the opinion on the constitutionality of international treaties that are not in force, that are signed by the Kyrgyz Republic, as well as giving conclusions to the draft law about changes and additions to the Constitution. The Constitutional Court will have the following tasks: giving official interpretation of the Constitution, solving disputes on the competence between the state power branches, and giving its conclusion about the maintaining established order of the claims against the president. As experts mention, the most positive aspect in this constitution is the transformation of Constitutional Chamber into the Constitutional Court and assigning additional powers to it. Currently, Constitutional Court is in the standby mode, waiting for the adoption of the constitutional law and the Constitutional Court that is introduced to the parliament of the country, and we hope that will be adopted in the near future. For information, I'd like to inform you that according to the law about the Constitution, the acting judges of the Constitutional Chamber of the Supreme Court of the Kyrgyz Republic will be acknowledged as the judges of the Constitutional Court of the Kyrgyz Republic and will keep their powers for the whole periods of their term. This is briefly about the current situation regarding the novelties in the system of constitutional justice after constitutional reform. Now I'd like to talk about the main topic of our meeting, which is the execution of decisions of constitutional courts. The specificity of our situation is also about the fact that my report will be devoted to the practice of execution of the decision of the Constitutional Chamber before its transformation into Constitutional Court. As Constitutional Court is its legal successor, then it will further monitor the execution of the decisions taken by the Constitutional Chamber. While being a Constitutional Chamber since its formation in 2013, and probably you know that after the events of 2010, the Constitutional Court of the Kyrgyz Republic was transformed into a Constitutional Chamber, and in reality started its work only in 2013. And as of 1st of May 2021, Constitutional Chamber adopted only 117 decisions and one conclusion. These are final acts. Of them, decisions on recognizing legal acts as compliant with the Constitution, 72 final acts. Decisions on recognizing appealed legal acts as being controversial or non-partially incompliant with the Constitution, 45 decisions. So 1/3 of all the decisions taken by the Constitutional Chamber, we can say that Constitutional Chamber found 4 controversies or partial incompliances of the act subject to appeal. Constitutional Chamber monitored on a continuous basis the execution of its decisions, and the results of monitoring and analysis of information provided by the lawmaking bodies, which acts were the subject for the consideration by the Constitutional Chamber, shows that as of 1st of May this year, of 64 decisions that implied the necessity of introducing changes to the legislation, non-executed are 23 decisions of Constitutional Chamber, 23 decisions of the Constitutional Chamber. Zhogorku Kenesh of the Kyrgyz Republic adopted 2 laws that are under the signature by the President. 11 bills approved by the relevant decrees of the Cabinet of Ministries and submitted for consideration to Zhogorku Kenesh. 2 bills are under consideration by the Cabinet of Ministries, and 8 bills are at the stage of the developments by the Ministry of Justice. In general, the results of execution of decisions of Constitutional Chamber are satisfactory currently. Such positive trends emerged after the amendments in 2017 of relevant legislative acts on optimization of the execution of the decisions of Constitutional Chamber. It should be mentioned that in this law on Constitutional Chamber, before this year, 2017, there were no legislative mechanisms envisaged for the execution of decisions of this constitutional review body. And because of that, there were like special cases in the execution of the Constitutional Chamber decisions when state bodies passed to each other the matters of related to execution of its decision. As a result, this execution was delayed without any grounds. On the 22nd of June 2017, in order to overcome this situation, the parliaments of the country introduced legal mechanisms for the execution of decisions by the Constitutional Chamber. According to this, the website of Constitutional Chamber was recognized as official source for publication of its decision. It was done in order to ensure timely execution of its decision, as the introduced changes envisage that there will be specific timelines for the development of bills for their further submission to the consideration to the parliament. And these timelines, they were calculated from the date of publication of the act by the Constitutional Chamber on its official website. There were like exact timelines introduced for the implementation of the Constitutional Chamber decisions. For example, if the decision of the chamber recognizes that the law, code, or the act is recognized as incompliant with the Constitution fully or partially, or the decision that comes from this, there is a necessity to fix this gap in this legal regulation. And the government, within no less than 4 months after publication of the decision of Constitutional Chamber at its official website, introduced to the parliament relevant bill. So, and these bills were subject to consideration by the parliaments, provided that there was relevant decision of the government. In order to bring in line with the decision of Constitutional Chamber and Constitution of the bylaws, there is a 3-month period indicated for lawmaking bodies, which acts are subject for the consideration by the constitutional review. To implement these amendments, the government also took the decree where Ministry of Justice of the country was identified as the executive body for the development of legal acts coming from the decisions of Constitutional Chamber. Within the framework of introduction of amendments on the execution of decisions of the Constitutional Chamber, there were also changes envisaged to the law about regulation of Zhogorku Kenesh, our parliament. There were the following changes: that draft constitutional laws and laws that are coming from the decisions of Constitutional Chamber shall contain norms that are coming exclusively from the meaning and content of the decision of Constitutional Chamber. And the law about the legal acts says that the draft legal acts developed for the execution of the decisions of Constitutional Chamber are not subject to public discussion. These changes were introduced in order to eliminate introduction of separate amendments that will change the meaning of the draft law developed in order to execute the decisions of Constitutional Chamber. during its discussion and adoption by the parliament. And this decision shall be subject to their execution. The positive trend is that the new draft law about constitutional court that we're waiting for now has also similar legal mechanisms for the execution of constitutional court's decisions. The difference is that the time for the preparation and submission to the cabinet of ministries to the parliaments of the country will be reduced. And also this time period will be reduced for the adoption of bylaws to implement the decisions of this constitutional court, and they will be reduced from 3 to 2 months. Like at the level of the parliament during 2 months, and at the level of bylaws, they will have also 2 months. I would like to mention that there is a need for the direct legal mechanism for the execution of decisions of constitutional review justice body, but there should be indirect, active participation of state bodies and officials. The officials that take decision for the implementation of acts of constitutional review bodies shall understand their responsibility. They shall understand that they are not implementing the wish of some institute of power, and they are implementing constitutional values and principles, and they're implementing them in practice. It shall be taken into account that the effectiveness of the execution of decisions of the constitutional justice body has specific and significant role that contributes to the formation of the optimal way to achieve stability of not only constitution but the whole legal system in the state. Also want to add a couple of words about law enforcement bodies. Still, we have facts when courts continue to apply norm which was recognized unconstitutional, even which was cancelled by the parliament, which is the example of the abuse of law. This says that we will also have to conduct effective campaign on the increasing the capacity of judges in the area of constitutionalism. The execution of decisions by the Constitutional Court depends also on the attitude of the public to its decision. If the trust of the civil society to Constitutional Court is high, then there will be high level of execution of its decisions and less political pressure. I would like to mention that decisions of Constitutional Chamber have its authority, and that are also, which is also understood positively by the public. In the context of constitutional reform, I would like to mention that today there is a question about non-fulfilled decisions of Constitutional Chamber. I think that despite the change of the name and the extra powers of Constitutional Review Body, the decisions of the previous body shall be fulfilled in part which does not controverse the new constitution. I would like to thank Venice Commission and Mr. Bukikio, who always supports constitutional review body in our country. I'm confident that in order to ensure constitutionalism in Kyrgyzstan, our cooperation with you will be further strengthened. Would like to thank also Constitutional Council of Kazakhstan for this initiative to conduct this seminar, and the program on the rule of law in Central Asia for organizing our meeting. I wish all of us fruitful meeting. Thank you for your attention.
Thank you very much, Mirgul Raskulbekovna, for a very interesting report. We wish you success with the transformation of your constitutional chamber and the establishment of the Constitutional Council of Kyrgyzstan. Next floor goes to the judge of the Constitutional Court of the Republic of Tajikistan, Mr. Jamshedzoda. Please, the floor is yours. Good afternoon. I hope you can hear me. Yes, we can. Dear participants of this seminar, dear colleagues, ladies and gentlemen, let me first of all welcome you on behalf of the Constitutional Court of Tajikistan and express my gratitude to the Venice Commission of the Council of Europe and the Constitutional Council of the Republic of Kazakhstan for organizing this seminar on a very relevant topic of the constitutional justice, the execution of the decisions of the constitutional courts and equivalent bodies. I would also like to thank the European Union and the Council of Europe, because this seminar is being held as part of the implementation of their initiative on the rule of law in Central Asia. It should be noted here that the organization and conduct of international seminars and conferences where different issues related to the rule of law and the work of the constitutional review bodies are discussed, well, these seminars and conferences are of an international importance. And in this regard, the event that is being held today with the involvement of the representatives of the national authorities, EU and the Council of Europe, in the environment of openness and devotion to democratic development of our countries, we see another proof of the role of constitutional council, courts and equivalent bodies, because they serve as a guarantee of stability and sustainability of the national legal system, and they ensure constitutional legality of our countries from year to year. Dear colleagues, undoubtedly the topic of this seminar is devoted to the execution of the decisions of the constitutional courts as bodies of constitutional review, and this topic is highly relevant and very important, as the state of constitutional legality in Tajikistan and in other developed democratic countries plays a crucial role, and to a greater extent depends on the execution of the decisions of constitutional courts by all the bodies of government, including the legislative and executive bodies. So the bodies of constitutional review play a crucial role in ensuring constitutional legality in different countries, as they demonstrate high level of legal culture of the government bodies and state officials. They also demonstrate the consent of the address to the Constitutional Court with the proper implementation of the constitutional provisions of the country. Implementation or non-implementation of certain provisions by the constitutional body, review bodies, doubts the proper mechanism that was aimed at achieving the rule of law and the direct impact of the constitutions of each country, which mostly covers the protection of human rights and freedoms and the control of the constitutional jurisdiction. Regardless of the fact that the constitutional justice is something brand new for Tajikistan, the Constitutional Legal Institute of the Constitutional Court of Tajikistan plays a greater role lately, because it plays a crucial role in the execution of the decisions of the constitutional courts. Thus, this shows the rule of law and protection of human rights and freedoms. An important legal guarantee for the execution of the decisions of the constitutional courts of Tajikistan is the Constitution of Tajikistan, and under Article 89, the acts of the constitutional courts are final. According to the constitutional injunctions, the acts of the constitutional are considered final and they cannot be appealed, or they are not subject to any further appeal. The decisions of the constitutional courts do not need any confirmation from other state bodies, and clear execution of the decisions of the constitutional courts is an important element of ensuring constitutional legality within the country, and this determines the effective work of the Institute of the Judicial Control. Therefore, in order to ensure the effectiveness of the acts of constitutional courts and the prevention of controversies with the Constitution, the new program of the judicial and legal reforms of the Republic of Tajikistan for 2019 to 2021 was adopted, and with regards to Part 5 of Article 60 of the Constitution of Tajikistan, just recently the new amendment was made, and according to this amendment, the readoption of acts is prohibited. It should be noted, though, that in this sphere, there are some unresolved issues related to the lack of normative and legal acts or norms regulating the mechanism of resolution of problems by the constitutional courts, which has a direct impact on the increase in efficiency of its acts. And the experience shows that the implementation of decisions of the constitutional courts and equivalent bodies based on the implementation of its legal functions this makes the constitution real and efficient, and that is why the constitutional bodies that ensure the rule of law as well as protection of human rights and freedoms need to include a mandatory element of the execution of legal and judicial acts. And this determines the presence of the legal mechanisms. And we find it relevant for the government bodies to have legally binding procedures of execution, as well as punishment measures or sanctions for non-execution of the decisions within a certain time frame. The responsibilities will be considered as, or the liability will be considered as necessary measures of punishment depending on implementation or non-implementation of the decisions. And the Constitutional Court of Tajikistan, as the body of constitutional review, takes into account the acts that complete the constitutional justice in the form of decrees that reflect the legal position. The statistics and the experience shows that from year to year, there is the higher intensity and the number of complaints to the Constitutional Court of Tajikistan. And it should be noted here that the majority of complaints include the issues, the consideration of which are not within the functions of the constitutional courts. That is why the Constitutional Court sends responses to the claimants explaining the authorities of the constitutional courts. A number of issues have been considered in Tajikistan in order to ensure the rule of law and constitutional legality, as well as the protection of human rights and freedoms. And, for example, the Constitutional Court of Tajikistan issued a decree from 2011, the 16th of October, according to which the Article 1, Part 3 and Article 333 of the Civil Code of Tajikistan indicate that other parties to the process that do not have a right of appealing the decisions of the Supreme Court of Tajikistan that were made when considering the cases of the first instance. The parties to the process are not entitled to file their appeals when it comes to consideration of cases of the first instance by the Supreme Court of Tajikistan. Also, on the 20th of January of 2005, certain amendments were made to the article of the 17 and 19 and Article 88, Part 2. And these amendments were about the non-provision of the right to file a supervisory complaint in case the economic courts make their decision under Article 17 and 19 and Part 2 of Article 88 of the Republic of Tajikistan. So on the basis of this, the parties to the process, after the adoption of the amendments, were given the right to file their appeal. Each of the acts of the constitutional courts of Tajikistan requires some clarification in order to eliminate some uncertainties in the legal jurisdiction and in ensuring constitutional spirit of the law. In order to effectively resolve these problems, we pay attention to the law enforcement activity and identification of gaps in regulations, which include lack of consent between different legal acts. These defects of the legal regulation matter a lot because the Constitutional Court deals with them during its work, and the problems in legislation must be resolved because the Constitutional Court needs to know how to interpret the laws and provisions properly, especially when it comes to violation of some constitutional rights or freedoms. And the methodological criteria for the assessment of the problems of legislation include the Constitution of the Republic of Tajikistan, that includes the principles of the rule of law, legal state, the balance of the constitutional rights, values, and principles, support of citizens, maintenance of trust of the citizens, presumption of innocence, the limitation of liberties, and as well as the system of checks and balances. Of course, it would be expedient to ensure a more effective cooperation with the constitutional review bodies and the higher state authorities in order to timely implement the decisions of the constitutional courts, because the majority of these decisions are under the jurisdiction of these bodies. The specific internal normative and legal acts need to be accounted for in establishing measures of personal responsibility for non-implementation of the decisions of the constitutional courts and equivalent bodies, because this is another important aspect that will help us resolve the problem of non-execution of the decisions of the constitutional courts. And according to the Constitution of the Republic of Tajikistan, the acts of the constitutional review bodies are final and are not subject to any appeal from any stakeholders, parties, or public associations, as well as individuals or citizens. In Part 5 of this article, there are norms according to which the law and legal acts or their provisions may lose their force or effect in case they are considered by Constitutional Court as non-constitutional. So, according to the Constitution of Tajikistan, the Constitutional Court of Tajikistan establishes norms related to the execution of the decisions of the constitutional courts. So, according to Part 1 of Article 60 of these, all the legal acts and decisions of the constitutional courts are enforced since the moment of adoption of these decisions, since the moment of their declaration. And there are two more acts of the constitutional courts of Tajikistan that are also considered as legally binding and final. Part 2 of Article 61 of the Constitution says that the decrees and decisions of the constitutional courts of Tajikistan are published in mass media, and other acts can also be published in mass media. The norms of constitutional law are one of the ways to ensure constitutional proceedings, and these norms say that the execution of decisions of the constitutional courts and equivalent bodies must be implemented in a timely manner and published respectively in mass media. The list of state bodies and parties to the constitutional proceedings are also defined in this article. By sending final decisions, the Constitutional Court of Tajikistan is obliged to inform the government bodies to take decisions on the execution of the acts of the constitutional courts. And the Constitutional Court has exclusive rights to give the order to the government bodies on the implementation and execution of the constitution of the decisions of the constitutional courts. Of course, in order to suspend the norms of law or some legal acts which are considered unconstitutional, or in order to prevent this in the future, it takes a timely execution of the decrees of the constitutional courts by relevant stakeholders. And that is why, according to the article of the Constitution, there is a norm that says about the appropriate execution of the acts of the constitutional courts of Tajikistan, and non-execution of these acts result in certain sanctions and punishment. And of course, only actual execution of the decisions of the Constitutional Court makes justice real and complete. And for that, there is a need in legal embodiment. And it should be noted that according to Article 363 of the Criminal Code of Tajikistan, there is a general norm that says that the non-execution by the government officials or local authorities of the decisions of the constitutional courts and non-execution by different kinds of organizations or rural authorities and so on and so forth equals as the hindrance to justice. If we look at the constitutional review bodies, they do not have any mandatory mechanism to force other bodies to execute the decisions, and the constitutional review bodies can also put forward clear arguments and justifications. Timely and complete execution of the decisions serve as the mechanism to ensure a universal legal field that is determined by the constitution of the country and as a sign of the sovereignty of the country, and the effectiveness of the implementation of decisions of the constitutional councils or courts are in line with the concepts of effectiveness of the constitutional review and justice.
Well, the understanding of this interlink is a comprehensive and systemic approach to the understanding of execution of constitutional court decisions. Of course, here we should understand timeliness of the execution based on the availability of the complete parts in the decisions of the Constitutional Court based on the active legislation. The international experience shows that the effectiveness of the judicial act's execution depends on the completeness and legality of the regulation of the execution of these decisions, and incomplete legislative regulation contributes to the untimely execution of these decisions. Analysis of the legislation shows that legislative regulation is not enough for the implementation of constitutional court decisions by the local executive bodies and the responsibility for that. And it should be mentioned that this entails the long unfulfillment of the decisions of the constitutional courts and also acts that breach human rights. Untimely execution shows problems in the legislation and legislative regulation that also is related to the measures of responsibility for unfulfillment of these executions. Unfortunately, this execution of these decisions is assessed only by the indicators that show the quality of the consideration of these processes that are not that don't include the fulfillment of the constitutional acts. And in this regard, we would like to express our statements that we agree with certain legal scientists that within the framework of the legislation that defines the legal basis of the state bodies to include the provision that defines the mandatory fulfillment of constitutional review bodies' decisions and to improve the procedure for the execution of the decision of constitutional courts. And in conclusion, I would like to thank the organizers of this event for thorough preparation. I hope that such high-level events will further be conducted again, and we will have more opportunities to discuss both theoretical and practical relevant questions related to this rule of law and the role of constitutional control review bodies in ensuring constitutional legality. Thank you very much, Mr. Jamshed Zoda. Please convey our warm regards to the chairman and to all the judges of your court, distinguished participants of the seminar. According to our agenda, we move to our experts, and I would like to give the floor to the judge of Constitutional Court of Bulgaria, Vice President of Venice Commission, to Mr. Filip Dimitrov. Please, Mr. Dimitrov, the floor is yours. Many thanks, Mr. Chairman, Mr. President. For me, this is a great honor to participate in this online seminar, Kazakhstan, in Kazakhstan, and I'm happy to have this opportunity.
The rule of law and the maintenance of human rights and liberties are extremely important. But if we don't have the main element of representative democracy, which is the division of powers, the other two can turn into a flood of sweet words to no particular effect. And in fact, one of the main challenges, is it okay? I mean, can you hear me? Вы можете услышать меня?
Yes, we can hear you. Yes, we can hear you.
So the main challenge to constitutional courts, like the Constitutional Court is my country, is that in fact, they have a specific position in the institutional structure and they do not belong to any of the branches of power. The Constitutional Court is not a court per se. And this is why its decisions are final and that there's no appeal for them on the one hand. On the other hand, one of its main functions is to maintain the division of powers and not to interfere into the relative weight of the activities of the different branches. For this reason, the execution of the decisions of the Constitutional Court opens the door to a number of challenges. And the way they are addressed is to a large extent the guarantee or the lack of guarantee for the importance, respect for, and acceptance of the Constitutional Court activity. I have to say that I'm proud that in my country, the reputation of the Constitutional Court is particularly high. And I believe it is due to an evolution of the constitutional developments up to now, which gives it the possibility to maintain the constitutional principles on the other hand, and the division of powers among the other institutions on the other. As a matter of fact, in my country, there is no individual constitutional appeal, which to a large extent reinforces the role of the Constitutional Court as an instance of no appeal and as a sui generis institution of arbitration among the different institutions of power. One of the main reasons for the execution of the Constitutional Court decisions to be effected is that they are practically executed ex lege, or I would even say ex constitutione. And for this reason, the less other institutions have to do in order to perform this execution, the better for its efficiency. The Constitution actually says in Article 151 that the decisions shall enter into effect 3 days after their promulgation, and from the moment of their effective date, the acts declared unconstitutional cease to exist in the legal sphere. At the same time, it is made very clear by the same article, paragraph 3, that the remaining part of the legal act, which is not declared unconstitutional, remains in force, which practically means that the Constitutional Court does not have the prerogative to add normative substance to the acts which have been challenged in front of it. Of course, the decisions of the Constitutional Court, as it is stated in the law on the Constitutional Court, are binding for all state bodies, corporate bodies, and citizens. And for this reason, the acts which are declared unconstitutional cease to be implemented. Of course, if the Constitutional found that they are issued by incompetent institutions, the effect is the same, they are null and void. But at the same time, an obligation for the legislation exists if a law is declared unconstitutional, this to be resolved by the legislation. As you can understand, this is something like a challenge because, after all, it gives room for the decision of another body on the execution of the Constitutional Court decision. In other words, it is rather easy to trace the execution through the system of the courts. It is specifically provided that the pending, when there is a challenge to a particular law in front of the Constitutional Court, the pending cases with the general courts are to be suspended. And the same is valid for the administrative courts. And when there are procedures in front of administrative institutions, this rule for suspension is also there. And if, according to Article 54, paragraph 1 of the Code of the Administrative Procedure, and Article 229 from the one on the judicial system, if there is, if this suspension is not effected, or if there is any decision which is contrary to the declaration for unconstitutionality on the part of the Constitutional Court, this is in itself a reason for cassation. Naturally, it is more complicated when it comes to the acts of the legislation and the way in which this implementation, this execution can take place. There are in fact two possibilities, and they have been directly addressed by the constitutional legislator and in the interpretative decision of the Constitutional Court recently about the moment in which the effect of the court decision takes place. As I mentioned, when it comes to normative acts, to acts of parliament which contain general rules of behavior, the effect of the Constitutional Court decisions is ex nunc. In other words, from the moment that they are in force, this law ceases, or this provision of the law ceases to exist. However, if you follow the same principle concerning other acts of parliament, like decisions which can be personal decisions or decisions which are exhausted by a single immediate effect, in these cases, such a proclamation would mean practically nothing. And to this effect, the mentioned decision number 22, number 3 of 2020 and 5 of 2019 have declared that in these cases, the effect of the Constitutional Court decision is ex tunc, which would mean that if a decision produced in an unconstitutional way has been made about filling in some position or abolishing or creating an entity, etc., the effect of the Constitutional Court will, the decision will make this act invalid from the very moment of its being pronounced. There is another challenge which affects the issue of implementation, especially on the part of the legislature, which is connected with the fact that when the Constitutional Court would declare a certain provision of a law unconstitutional, there is a possibility that before that, there might have been another one. And if this is an amendment, the question will be raised of whether it will cover the previous provisions of the law. For a period of time, there was a practice that, in fact, the abolition, the declaring the anti-constitutionality of a certain provision would restore the previous legal situation. However, it is very clear that under certain circumstances, it might turn out that the previous, even unchallenged provision has been anti-constitutional too, and in fact, a clumsy or not very efficient attempt on the part of the legislature has been made to fill in, to correct this situation. This is why the issue of the abolition of this provision has been decided in favor of making the whole provision null and void, which means that nothing can come in its place if new activity on the part of the legislature has not been performed. This creates a possibility of the occurrence of lacuna in the law. And this is, as a challenge to the Constitutional Court, it made every effort to find a way in which Constitutional Court decisions should not, or should at least diminish to the maximum extent the possibility for the creation of such lacunae. To give you an example, we have recently had challenged the act on the financing of political parties. It turns out that the way in which it was formulated, it gave no limits to the financing by corporate bodies, even when they have, without any further explanations, which means that even if they had some kind of state participation or connection, etc., they might have been there too. Evidently, the problem was with the stricter definition of these bodies. On the other hand, being unable to add additional elements to the provisions, the Constitutional Court was faced to the possibility to either leave it the way it is, or by declaring it unconstitutional, to practically make it impossible for the particular period of time for any corporate player to financially support political parties. Whether this is good or bad is a different issue. Whether it fits into certain best standards is also another issue. The point is that technically, by creating this lacuna, one can expect that the parliament will be eager to find the way to fill it into it some kind of more acceptable and constitutional provision. However, it is again a matter of wisdom, and going back to this arbitration role of the Constitutional Court, to find the way in which to minimize the possible negative effects. In other words, by maintaining strictly the rule of law, to be able to maintain the division of power and the freedom of every branch of power to make its even wrong decisions if they are not anti-constitutional. Thank you.
Thank you so much, Mr. Dimitrov, for a very interesting report. The experience of Bulgaria helps us learn in details about certain aspects of the topic at table. Next floor goes to the judge of the Constitutional Court of the Czech Republic, Madam Katerina Simachkova. Please, the floor is yours.
Can you hear me, please?
Yes, we can.
Thank you. So, ladies and gentlemen, thank you very much for inviting me to this interesting international seminar on execution of decisions of constitutional courts. In my speech, I would like to share with you the Czech Constitutional Court's experience regarding this issue, which is legitimacy and authority of the Constitutional Court as key factors in implementing landmark decisions of the court. I will also comment on how the court itself can contribute to acceptance and adequate enforcement of its decisions. I will present several Czech Constitutional Court's decisions in which particular laws that interfered with political competition and the life of political parties were declared unconstitutional. I will then describe the response of the parliament, including the political parties concerned to these decisions. In a truly democratic state where trust between the authorities exists, decisions of the Constitutional Court or Supreme Court are respected not only as to their interpretation, but also by executing them efficiently. It matters whether the reasons why the Constitutional Court held a challenged statute unconstitutional are taken seriously, so the decision can be implemented correctly into the law. Respecting these reasons when drafting new legislation ensures good execution of the court's decision and is not only essential for protection of human rights, but also favors good governance and enhances the rule of law. Good implementation of decisions depends on the court's authority and respect for it, demonstrated by other institutions and authorities, and also on the court's legitimacy and respect for it in society. The media also play a major role in the building this respect. The more the society respects the court, the more complicated it is for political actors to disregard its decisions. Based on these observations, I claim that besides quality decision-making supported by persuasive reasoning, the court's role is also to communicate, if necessary, directly with the public and convince people that the decisions of the court are significant and right. This is particularly important in countries where political actors are not sufficiently respectful of the judiciary and there are not enough good journalists with legal training who could explain and endorse judicial decisions. To support this idea, I will present 3 cases decided by the Czech Constitutional Court. In the first case, I chose the Czech Constitutional Court annulled a part of the Act on Association in political parties and political movements regarding financing of political parties. It is judgment number PL/US 53/2000. According to one of the challenged provisions, political parties would receive a financial contribution of 1 million of Czech crowns per mandate of a deputy or a senator. The Constitutional Court found this provision unconstitutional because it interfered with the free competition of political parties, disproportionately disadvantaged small political parties compared to the bigger political parties represented in the parliament and prevented new political actors from entering the political competition. The legislator responded to the judgment by lowering the amount of the financial contribution to 900,000 Czech crowns. Thus, the judgment was complete with. But the way it was done seemed, in a symbolic way, like a slap in the face for the Constitutional Court. In another case, the Czech Constitutional Court annulled a constitutional act which shortened the term of office of the Chamber of Deputies to enable yearly elections. It is judgment number PLUS 2709. The court found a violation of the Constitution's material core because the challenged act was unconstitutionally individual and retroactive. Politicians then even considered adopting a new constitutional act so they would not have to comply with the court's judgment. However, it was clear that the court had a strong public support. The court also actively communicated its decision in the media. For example, there were interviews with the judges, including the usual rather shy judge rapporteur, or a TV program about the background of the court's decision. Eventually, the politicians complied with the judgment because they understood that disrespecting it would reduce their popularity among the public. Last but not least, the Czech Constitutional Court in a recent case annulled several provisions of the Act on Parliamentary Elections containing the election formula and electoral thresholds for coalitions. It's the judgment number PLUS 4417. The court held that read as a whole, the law deviates too much from the proportionate electoral system required by the Constitution and violates voting equality. The judgment provoked some criticism from the political actors, especially because it was delivered quite shortly before the upcoming elections. The court again actively explained the judgment to the public, but this time the dissenting judges were very confrontational, which might have negatively affected the public opinion. Fortunately, everything ended well because politicians behaved constructively and managed to adopt a new law in time. Although the solution they eventually chose might not have been the best one, it was good enough to comply with the court's judgment. Finally, when the court reviews norms on elections or political parties financing, it is important that the court protects the political competition and rights of political minority. The court enters a terrain in great part occupied precisely by representatives of political parties that are directly subject to this legislation, which might be dangerous. But the court has to do so because otherwise there would be a risk that the parliamentary political parties would tailor the legal rules on elections and financing of political parties to best suit their interests. To sum up, in a well-functioning democratic state with strong human rights and rule of law guarantees, the political actors naturally respect decisions and reasoning of the Constitutional Court. However, in states where this is problematic, the Constitutional Court must actively explain its decisions and seek support in the society. It is the public legitimacy and authority of the court that forces political actors to implement and enforce the court's landmark decisions, even if they affect interests of the currently ruling politicians and political parties. That brings me to the end of my presentation. Thank you for your attention.
Thank you for your informative speech, Madam Simachkova. Your experience is quite valuable for us. Constitutional Court of the Czech Republic is one of the first constitutional review bodies in Europe. Just recently, you celebrated 100th anniversary, and I had an honor to speak during the Congress of the European Constitutional Courts that was very well organized. Thank you very much. And the next floor goes to the former chairman of the Constitutional Court of the Republic of Moldova, member of Venice Commission of the Council of Europe, Mr. Alexander Tanase. Please, Mr. Tanase, the floor is yours. Many thanks, Mr. Chairperson. I hope you can hear me. In fact, today's discussion is not only interesting from the intellectual perspective, it's also has quite significant practical significance, especially for Central Asian countries. While being in Central Asia, quite often we discuss the problem of the Constitutional Court's decision execution with our colleagues, and I see Bilgul Raskulovnu and our colleagues from the Constitutional Court of Tajikistan, where we had just recently an opportunity to have a meeting with them. And the problem of constitutional courts is quite relevant. So given the essence and spirit and meaning of constitutional courts, well, the fulfillment of the decisions of constitutional court is mandatory and important condition for the proper functioning of state power and for the strengthening of legal state. The defining during during the reaction to the decisions of constitutional court shall be legal. Yes, can you hear me? Yes, we can hear you. Yeah. So the defining here shall be legal factors and not political factors, especially if they envisage certain obligations for certain subjects. Therefore, there are no doubts that legal character and the purpose of the decisions of constitutional courts requires not only the execution, but also the establishment by the law of a number of legal guarantees for their execution. Let's try to answer the question, what is the role of the Constitutional Court in the light of the execution of its decisions? In order to answer this question, it is very important to identify who is responsible for the execution of constitutional court decisions. Well, ideally, of course, given the principle of constitutional loyalty, the legislature shall be responsible primarily for the proper regulation of the procedures of the execution of constitutional court decisions. Unfortunately, in practice, it is not always the case. Quite often, constitutional court decisions have some political significance, and legislators sabotage the decision of constitutional court, even though they must execute them. And we should always try to understand what is the reason for that, and how non-fulfillment of these decisions takes place. Well, given the experience of Central Asian countries that I have studied, we can identify two main elements. First of all, it's not fully clear regulation on the constitutional level of the procedure for the execution of constitutional court's decision. And the second element, which is also important, is constitutional courts do not ensure clarity and certainty in their decisions. To understand how it is revealed in every particular case, we need to analyze the legal acts with regard to the fulfillment of constitutional court decisions and cases for this non-execution. If we check the regulation, for example, in the constitution of the Kyrgyz Republic, Tajikistan, Uzbekistan, and maybe Kazakhstan, and with Kazakhstan the situation is different a bit, as it's constitutional council which is closer to the French model rather than to the classic model. What we will see in the regulation in the constitution of these countries, well, it is the following. The wording is quite ambiguous, and that enables double interpretation. In this regard, this differs significantly from the regulation embodied in the constitution of European Western states, where such provisions are clearly regulated. Since today I will talk about the experience of the Republic of Moldova, I want to tell that we don't have decisions that were not executed during the whole history of the Constitutional Court existence. There was only one decision that was not executed, but this was the impetus for the Constitutional Court for interesting interpretative decision. And in order to eliminate all uncertainties and possible ambiguities in the interpretation of the procedure for execution of these decisions. In the Constitution of the Republic of Moldova, it is clearly stated that the law and other normative acts are not effective as soon as the Constitutional Court takes a relevant decision. This prevents from different interpretation, for example, that there should be a third body, for example, parliament or the government or the president, who somehow should be involved in this process or make void certain acts or revise it. In order to make it even more clear, in two laws. The first is about the Constitutional Court. Once more, again, there is more detailed information about how the Constitutional Court's provisions shall be interpreted with regard to the fact that normative acts that are recognized unconstitutional lose their effect and become null and void from the moment of Constitutional Court decision taking. It is also related to the normative acts and consequences of normative acts, or its part. That, well, what does it mean? That there is a clear segregation between the competence of the Constitutional Court that recognizes either constitutionality or unconstitutionality, and the competence of the parliament that has a limited role in this process. Just from the legal database, it deletes certain provisions of the law, marking that they were recognized unconstitutional by the Constitutional Court of the Republic of Moldova. So this is very important element that at constitutional and sub-constitutional level there is a clarity and certainty in the regulation of how Constitutional Court decisions shall be implemented. And the second element is about the clarity of the decisions themselves. Well, sometimes Constitutional Courts quite often take decisions that are not clear, not fully clear, and even sometimes they may contain provisions that prevent others from the execution of Constitutional Court decisions. And in this situation, Constitutional courts are obliged, shall clearly envisage not only the consequences of its decision, and even political elements shall also be envisaged, and to state the formulated decision in a way so that they can be enforceable, they can be executed, and so that other lawmaking bodies will not have any opportunity to somehow impact the execution of these decisions. It is in particular related to the cases when constitutional courts state so-called legislative omissions. For example, when in some law certain aspects of social life is not regulated that has direct relation or influence on the human rights and freedoms. And if the Constitutional Court states this omission, it is very important for this statement to have some argumentation provided by the court. Maybe court can be more active in giving some temporary provisions with regard to how this norm of the law can be interpreted in the light of the Constitutional Court decision. In order for the Parliament, even if the Parliament delays certain amendments to the law, so that this will not impact the main constitutional human rights. We should understand that Parliament is a political body, and in all countries, in the majority of the countries, and especially in Central Asia, there is no imperative mandate. No one can oblige the Parliament deputy for any law. Therefore, constitutional courts are responsible in terms of the proper argumentation and statements of certain provisions. As for the experience of the Republic of Moldova, as I have said, there was only one case when Constitutional Court was not executed. It was about unconstitutionality of the law about social insurance. After the court decision, the Parliament introduced the majority of required amendments to the legislation, as the decision was quite difficult and Constitutional Court was not able to fully regulate all the aspects, but still certain parts of this law were unregulated. And then there was the question with judicial institutes, how to properly execute. Like on one side there is this Constitutional Court decision, and on the other side, there is updated law that contains same provisions of the law. And the Supreme Court approached the Constitutional Court with the request of explanation. And Constitutional Court used this opportunity to give broad interpretative decision where it explained in details on how this should work and where is the border between the competences of the power and and then explanation of the decision and the procedures for implementation of this decision. It was quite helpful. And Constitutional Court here established several important principles. I will mention them quickly. Principle of not taking required legislative measures by the Parliament regarding the fulfillment of certain decisions is equal to the non-fulfillment of its powers envisaged by the Constitution, meaning legislative powers. So given this principle, it turns out that Constitutional Court's decisions are mandatory acts that are based on the explanation of the essence of the constitutional question and the explanation of their meaning according to the challenge norms. The second principle is about the meaning and role of constitutional jurisdiction. The court defined that this is the sequence of the constitutional norm which is detailed in the mandatory execution of constitutional court decisions. And also, court defined that interpretation of the constitutional norms is mandatory for all the subjects of legal relations. It doesn't mean that it's only for the governments or for the parliaments. They're also mandatory for other bodies of state bodies. And the court defined that constitutional court decisions shall be executed without any formal conditions, and official interpretation of the Constitution has imperative character. So thus, Constitutional Court of the Republic of Moldova contributed to this quite serious, painful question for constitutional courts regarding the execution of its decisions. I think it's with any constitutional court when it faces such a problem, like somehow to define in its decisions and delete certain uncertainties, ambiguities of the law, or certain established administrative practices that help to interpret the law in a way that de facto will allow not to enforce it. And I would like to thank all of you for your attention, and I would like to wish all the participants of our seminars fruitful work.
Thank you so much for a very informative report, Mr. Tanasya. As always, you managed to focus and provide on details and provide these details on this very important issue. I would like to give next floor to the former president of the Constitutional Court of Georgia, international advisor, Mr. Georgi Papuashvili. Please, the floor is yours. Thank you, Mr. Chairperson. Thank you so much for giving me this opportunity to take part in this seminar. I would like to welcome colleagues and former members of the Constitutional Council, as well as our friends from other institutes, from the chambers of parliament, from Kazakhstani institutes, and I would like to welcome my colleagues from the Venice Commission. I will try to be brief because we are almost on the finish line, and if we have some time, probably it would be better for us to use this time for questions and answers. Well, I'm not going to go into details. That is why I will just provide some brief information. I will try to focus on the influence of the decisions of the constitutional courts on other legal relations, and there is a very interesting report provided by the Venice Commission for the Constitutional Court of Georgia that is actually relevant for all the courts. So I will try to briefly tell you about how the courts can protect themselves in order to make their decisions more effective, especially when the parliaments of some countries try to reduce the influence of the decisions of the constitutional courts. Since we have really excellent interpreters at the Constitutional Court, I will switch to the English language.
The effectiveness of the constitutional review is largely predicated upon the form, scope, and nature of the execution of constitutional decisions. For an individual filing a constitutional complaint, it's vital to be able to get an effective remedy from the Constitutional Court. Thus, effective implementation of constitutional decisions carries a crucial role in upholding the supremacy of the Constitution and the rule of law. The Constitutional Court of Georgia, similarly to the courts of other new democracies, has experienced important challenges related to the adjudication process, execution, and comprehension of its judgments. Nevertheless, even in a relatively short period of its existence, the court has been able to develop the case law, including novel interpretive instruments, to eliminate factors impeding the court's ability to effectively exercise its mandate. According to the constitution, like in many other constitutions, according to the Georgian constitution, a judgment of the constitutional court shall be final. An act or a part, therefore, that has been recognized as unconstitutional shall cease to have legal effect as soon as the respective judgment of the court is made public, unless the relevant judgment envisages a later time frame for invalidating the act or a part therefore. By the way, it's a separate subject about the postponement of the execution, the decision of the court, and we don't have time for that, but in the future it's interesting how it works in different countries. Our colleagues already mentioned in other countries also the impact of the postponement of the execution of the decisions of the court. With regard to the effects of constitutional court acts, which announce a legal norm upon the various fields of law, there is not a uniform approach in the Georgian legislation. It is important to make distinction between different fields of law, namely civil, criminal, and administrative law. With respect to the criminal cases, the legislation does have the answer, and as it provides for redress, reopening of the case, or retrial in criminal cases, if the disputed provision upon which the case in a criminal court had been decided is found unconstitutional by the Constitutional Court. In administrative and civil cases, nonetheless, there are no clear-cut solutions, as relevant legislation doesn't regulate the issue. Yet, in administrative cases, judicial practice in Georgia, both ordinary courts and the Constitutional Court, tend to recognize the importance of an effective mechanism whereby the flawed legal norm has caused a damage to the party in question and the responsibility of the state is involved. If the state is involved, then it's the practice is that the ordinary court can reopen the case. Civil procedure, however, doesn't recognize the possibility to reopen a case if such a case had been decided in the past based on an unconstitutional norm. Interestingly, there are a number of cases pending before the Constitutional Court of Georgia, even now requesting the court to rule on the effects of its acts in the civil proceedings. And the question in a nutshell for the court is to determine the boundaries of decision-making by the acknowledging ex post facto effect of its decisions in civil cases or denying the complaint. The arguments for upholding the claim refer to the principle of supremacy of the Constitution, whereby already decided civil cases, which in fact may still have significant implications to the party in question, need to be reopened if it is declared by the Constitutional Court that they were based on an unconstitutional legal norm. On the other hand, the avoidance of disorder in the whole legal system gains relevance, because in case all the previously decided civil cases become eligible for consideration, the principle of legal certainty may suffer, principle of res judicata, finality of judgments. In its amicus written by the Venice Commission, I mentioned at the beginning, Venice Commission noticed that one of the inherent characteristics of the rule of law is the principle of legal certainty and the protection of citizens' trust in the law, which includes the prohibition of retroactive effects of legal regulations and their provisions. Conversely, effectiveness of constitutional review mechanism needs to be ensured. On the whole, in choosing a system of effects of constitutional court decisions, a balance must be found between the individual remedy on the one hand and legal certainty on the other. In systems that provide for a normative constitutional complaint, the individual act applying the normative act cannot be attacked as such before the Constitutional Court. The control by the Constitutional Court does not concern the implementation of the normative act. As a consequence, a normative constitutional complaint is not an effective remedy if the unconstitutionality resides in the application of the norm, but not in the norm itself. As concerns the validity of the unconstitutional legal provisions, there are two schools of thought. One, unconstitutionality of the norm as from then, so-called ex tunc effect, and when the unconstitutionality when the act legal norm was adopted, and unconstitutionality is from now, ex nunc effect, when the court just decided that norm is unconstitutional. So it's this effect after just the decision of the court, not after the adoption of this norm. Only relatively few countries provide for ex tunc effect of constitutional court decisions. The German legal system is widely regarded as a well-known example for an ex tunc In this case, ex nunc means that the unconstitutional provisions are considered to be invalid as from their adoption of this norm. The decision of the Constitutional Court finding the unconstitutionality is not a constitutive act invalidating these provisions. It identifies provisions which are unconstitutional and which are already invalid. The advantage of this concept is in abstract clarity. The supremacy of the Constitution is regarded so important that unconstitutional provisions are invalid per se. However, in practice, a rigorous application of this concept would lead to unforeseeable results in individual cases, which are based on the application of the unconstitutional provision. For instance, a decision finding a provision on marriage unconstitutional, for instance, because of a contradiction with the principle of equality, would then result in the invalidity of all marriages concluded under this provision. This is, of course, an unacceptable result in some cases for the society. Therefore, even in states with ex nunc effect on the law itself, these effects are regularly excluded from the judgment that do not lose their legal force. The alternative model of invalidating unconstitutional provisions ex nunc is the most common. In its strict form, this means that the legal provision that was found unconstitutional remains even applicable to facts that arose before the invalidation entered into force, with the exception of the rule for the instant case, preferential treatment of a retrospective effect of the decision applying only to the complainant. Decisions of the Constitutional Court do not influence legal relationship that had been finalized before the publication of the decision. The logic justifying this solution is that the legal certainty is given a high priority over individual remedy. In order to provide a remedy in the case which led to the decision of the Constitutional Court, the rule for the instant case is necessary as an incentive for individuals to appeal to the Constitutional Court. The Austrian Constitution establishes a system of a strict ex nunc system with the rule of the instant case. The Austrian law stipulates that the law invalidated by the Constitutional Court shall continue to apply to the circumstances affected before the decision of the court, with the exception of the instant case. The court may, however, intend the fact of its decision to parallel cases pending before courts or administrative authorities at a certain point of time. So we have our two distinguished guests, one from Czech Republic and from Moldova, and two cases from both countries. In some countries, the Constitutional Court itself may decide on the effect of a decision finding a legal provision unconstitutional. In the Czech Republic, there is extensive case law on the issue of legal aspects of abstract unconstitutionality review. Findings of the Constitutional Court are considered constitutive legal acts and have in principle ex nunc effects. However, in exceptional cases, the Constitutional Court's findings have retroactive effects. They are admissible if they are absolutely necessary as a last resort for the purposes of protection of constitutionality, if they don't lead to disproportionate interference in legal certainty, especially in vertical relations if their constitutional provision regulates the relationship between a public authority and an individual who would benefit from the invalidation. The case law of the Czech Republic admits that when it comes to vertical relationship between state and individual, a finding of unconstitutionality may have retroactive effects because in vertical relationship, it is necessary to give priority to the protection of fundamental rights over legal certainty, a trust in the law. In Moldovan Constitutional Court, I believe in 2013, our dear colleague Alexandru was in court still, not still, but in the middle, let's say, as the president struck down the procedural law that precluded the reopening of civil cases by virtue of unconstitutionality of applicable law. The court indicated that the legislation needs to strike a fair balance between principles in individual remedy and legal stability by introducing a legislative time limit during which the reopening civil cases will be allowed for the affected third parties. The Venice Commission showed a slight preference for a combination in this amicus curiae, a combination of a system of invalidating ex nunc, including a special rule for the instant case, together with the possibility for the Constitutional Court to order retroactive effects if this is required, under certain conditions. In one of its opinions, in Montenegro, for example, the Venice Commission stated that general retroactive effect should be avoided, as this could have very costly a negative effect also on third parties. And it seems safer to have a general ex nunc effect, with the exception of the petitioner who should benefit respective effects of an individual complaint to the court. Such a system would give the Constitutional Court enough flexibility to establish a balance between the principles of individual remedy and legal certainty. However, such a preference does not mean that other systems are not in line with European standards from the complaint and to leave the for European standards. Now, briefly about how the court can somehow interfere itself as a negative legislation. In order to ensure effective protection of human rights, merely equipping the Constitutional Court with competence to declare provisions unconstitutional is not sufficient. In order to be able to completely exercise its mandate, the Constitutional Court needs to have a flexible legal mechanism of adoption of the judgment, as well as instruments for the implementation without the involvement of the legislative branch. And sometimes the legislative branch are not so eager to cooperate with the court in this area. So in Georgia, constitutional proceedings are regulated by law. Thus, in theory, legislation is equipped to create unnecessary obstacles on decision-making process of the court. So just as an example, and the Constitutional Court of Georgia as a negative legislature has already adjudicated on the constitutionality of the provisions regulating its proceedings and thus annulled certain cases. For instance, just briefly, we don't have much time, the court has declared the provision restricting the foreigner to apply to the court void and ruled that any individual legal person is entitled to lodge a constitutional complaint, thus broadening the scope of persons that can file a case to the court. Is the case of 2010. In another provision, the court has declared void and void was an impediment of using the interim measures during the proceedings. According to the law, if the Constitutional Court considers that the operation of a normative act may have irreparable consequences for one of the parties, it may suspend the validity of the disputed act or its relevant part until the final decision or for a short period of time. And then Parliament amended the legislation saying the court can still use this opportunity, but restricted it in time. So the Parliament said that it should last just 45 days. Maximum 30 days and plus 15 days, the president of the court can prolong. And Parliament thought that it should be shortened the period of time. But in 1 year after the application of public defenders, some NGOs, the court has found that its ability to suspend the application of the provision as an interim measure is derived directly from the Constitution, is not specifically stating in the text. The interim measure can be used at any stage of the proceedings, either by the chairman or the plenum. And the Constitutional Court in 2014, according to its decision, has invalidated legislative norm that set a limit of maximum 45 days, after which the suspension of the legal norm in question would become ineffective. So the court had to issue a final decision on the case where it suspended the impugned legal norm within 45 days, which rendered the Constitutional Court ineffective remedy and was found by the court to be a contradiction with the constitutional right on a fair trial. And last point, the judgment of the Constitutional Court not only declares the provision unconstitutional, but also determines the scope and meaning behind the constitutional provision. Therefore, the ruling by the court precludes the adoption of legislation with similar restrictions on the decision-making process of the Constitutional Court. When a new case is brought against a norm with the same content as one that was already found unconstitutional, the case is to be declared inadmissible and the challenge provision is declared unconstitutional. The Parliament sometimes used to play with the words. After decision of the court, Parliament used to change the wording, but the essence remained the same. In these cases, so the legislation empowers the court to pursue a case on summary proceedings, whereby the subject matter in question, a substance of the legal regulation, has already been found unconstitutional by the court before. Accordingly, at this stage, the task of the court is to identify whether the disputed provision entails the very same content of the older unconstitutional regulation. In case the Constitutional Court sees the legal provision in question is identical to the already annulled legal norm, it's going to issue a ruling, thereby rejecting the case on the merits, but finding the disputed regulation unconstitutional. And the court does not need to start a full-fledged hearing of the case again, just to declare that the decision was already made before. Спасибо большое.
Thank you so much for your attention. I tried to shorten my presentation at the very end. Thank you for your attention.
Thank you, Mr. Georgi, for making it brief. You exceeded your time limit by 5 minutes. Well, many thanks for such an informative report. You are our long-standing partner, and I'm sure that our fruitful cooperation will continue. Distinguished participants of workshop, we have finished with listening to our reports and to our experts. And now I would like to open our discussion. If you have any questions, please, the floor is yours. I'd like to remind you there is 1 minute for questions and up to 3 minutes for comments and answers. So who would like to ask any questions or comments? Well, no volunteers. Igor Ivanich, please. Igor Ivanovich Rogov, former chairman of the Constitutional Council of the Republic of Kazakhstan. Good day, Mr. Mami. Good day, distinguished colleagues, friends. I see many people I know. Well, I cannot stick to 3 minutes. Well, I'm really happy to see all of you. Dear colleagues, very interesting conference, a lot of information. Just wanted to mention some questions regarding recognizing laws unconstitutional. Like in Moldova, and in our case, there are no problems. So Constitutional Council recognized this unconstitutional, and there were no cases where certain body tried to use unconstitutional law. But there was one problem when Constitutional Council was chaired by another chairperson, when Constitutional Council fairly recognized the norms of international treaty as unconstitutional. Here, then there were problems for Kazakhstani side. There were no questions, as there was no possibility for its enforcement, but there were discussions with the other party that lasted for a long period, but then serious steps were taken and international treaty was corrected. I think here we can think of what can be improved. Second, those recommendations, and I agree here with my colleagues, those recommendations issued by the Constitutional Council in terms of the improvements of the legislation, and our colleagues from Moldova also, it's like it is impossible to impose this law to the parliament, as the meaning of legislative power changes here. The recommendations issued by the Constitutional Council of Kazakhstan to the government with regard to initiation of certain legislative amendments are of recommendational nature. And it's correct, as they cannot impose political will to the government. But in the law, in the initiative of Yelbasi, the first president, Mr. Nazarbayev, the following amendments were introduced. All the bodies are obliged to consider these recommendations and reply to these recommendations. And I think here the Constitutional Council acts effectively when, from time to time, submits this to the consideration by the parliament during the address. It's a good practice, and I think it will continue, and it is still there when there is an annual address at the Council on the legal policy. There is one question here regarding the interpretation, and it was quite fairly mentioned here. Well, Constitutional Council gave certain constitutional interpretation of certain law. or constitutional understanding, or with regard to one norm of constitution. But then it was like how to interfere, how to check that. There were a lot of comments regarding that. I think here it is important to have the political will of the management of the country and prosecutor's office and other bodies of control of legality. I think here some work should be done. And partially here we can use a new institute that was implemented according to the amendments of 2017, where the president, as the head of state and the guarantor of the constitution, has the right of approaching the Constitutional Council for the constitutional review in order to check the constitutionality of any legal, not only normative act, but also legal act. Here, probably some brainstorm is needed. And we need to think at scientific and consultative council. And if there is such a request, then whether interpretation of Constitutional Council can challenge certain law enforcement acts, including judicial acts. Like, we need to think here about that. We cannot say that we cannot do that. It's difficult. It's a specific problem. Another fact, one more. In 2017, amendments were introduced to Article 93, paragraph 3, that envisaged that Constitutional Council gives its opinion with regard that amendments to the Constitution do not touch unchangeable constitutional values, which is state independence, territorial integrity, and so on. I will not list all of them. Everyone knows these values. And what to do if these unchangeable values are touched upon or even breached by the other laws that are taken? Who should initiate that, especially with regard to constitutional laws? There is a problem. Of course, if certain decision is taken about constitutional reform sometime in the future, maybe we can consider it there. But maybe there is a sense to consider it during the improvements of the legislation. We can amend the constitutional law about the parliament, for example, in order to envisage this mandatory sending of these amendments to constitutional law to Constitutional Council before these amendments are signed by the president. So this conference is very interesting, and its significance. Well, probably nobody expected that all the answers will be given to all the questions, but I think because we have new questions now, that's the reason for which we should thank our organizers, Venice Commission, as the support by Venice Commission is very important for us. And I would like to thank our colleagues from the Constitutional Council. I really enjoyed this conference, not only with the information I received, but also I was really glad to see the faces of my friends whom I haven't seen for a long time. Well, sending hello to all of you and congratulating you with upcoming day of our capital, which will be next week. Thank you. Thank you very much, Mr. Rogov. Any volunteers? May I? Thank you. Today, in the reports of several speakers, there were questions related to the responsibility for non-execution or improper execution of the decisions of constitutional review bodies. Some speakers even referred to the relevant provisions of criminal codes of their countries that imply the responsibility for non-execution of court's decisions. As for the decisions of the constitutional justice bodies, then here this question has certain specificities. We know that the subject on legislative measures is Parliament, this executional subject regarding the questions related to the revision of earlier taken judicial judgments, courts, and law enforcement bodies. With regard to the later one, regarding the revision of all judicial acts, all procedural acts have relevant procedure established. So if these bodies fail to fulfill their obligations, and I wanted to ask here my colleagues, what will be the responsibility in this case for the non-fulfillment of these responsibilities? That's my question. Thank you. This is a question to our participants. Mr. Danese, please. A very interesting question, and it's quite relevant. Unfortunately, in this world we are living in, repressive side of any case is highlighted a lot, even though sometimes it's not a proper tool. You know, guillotine is not always the best tool to fight against dandruff. And I studied this problem in the majority of constitutional justice models that I have studied. There is no criminal responsibility mentioned anywhere, and it is not mentioned directly anywhere. Well, if we can initiate criminal case against the parliaments or the governments, then it's a game. Then this is the main difference between the ordinary courts and constitutional courts. Well, let's say as it is, constitutional courts' decisions are not just legal documents. These are legal political documents. We cannot exclude this. Canceling of the law is not just a legal step. It's a legal political step. Therefore, I think there is no space for criminal law. Criminal law shall be there where there are offenses and prosecutors, as this is public law. And here, I think we should use other tools, mainly the clarity of constitutional courts. You know, we are scared of judicial activity. Well, of course, when it is unnecessary, excessive, it can harm. We cannot replace parliaments in taking the normative acts, but in certain cases, courts shall have moral force, and in their decision should fully define, if needed, how certain decisions shall be executed. I always cite Professor Stolensky from the University of Warsaw, where he said that this is the question of moral power to refuse from the positive interpretation of the law. In certain cases, we shall understand that constitutional courts are also responsible for the supremacy of constitution. But in our model, constitutional court is responsible for the supremacy of the constitution, not president. Therefore, we should not limit ourselves to the positive interpretation of the law or ignore somehow or to follow this policy as an ostrich, that to follow the ostrich activity, and not to say what the court was supposed to say. You know, Igor Ivanovich Rogov mentioned many details regarding to eternal values, unchangeable values. I think even without understanding ourselves, we are now defining the scope and the topics for the next conferences. Thank you. Thank you, Mr. Tanase. Any volunteers today? Hello, Mr. Mami is a member of Scientific and Consultative Council. Distinguished Mr. Mami, distinguished colleagues, today we had an interesting seminar that raised a number of questions related to the execution of Constitutional Court's decisions and Constitutional Council decision in the Republic of Kazakhstan. I think these are the questions that have big practical value to my mind. And I think currently, For the Constitutional Council, the levels of the decisions of the Constitutional Council are relevant. For example, those normative decisions of the Constitutional Council that are related to the official interpretation of constitutional norms are of huge significance. And it is said here regarding these norms that they have equal legal force compared to constitutional norms. And accordingly, they are equal to the constitutional norms in the Republic of Kazakhstan. Therefore, it obliges all the state bodies in the Republic of Kazakhstan, citizens, officials, in their activity to follow the norms of the Constitution. And also those decisions of the Constitutional Councils that refer to the official interpretation of constitutional norm. And it seems to me that here there is a question of practical implementation. The questions related to the attitude to this type of normative decisions. And I think the role of constitutional courts and Constitutional Council of the Republic of Kazakhstan in particular is related to consideration of this question. And it has already been said here about the future agenda that is there. Agenda of other seminars or forums that Constitutional Council will conduct, so these questions can be raised there. In particular, I think we can engage state bodies, representatives of state bodies, in the discussions that we have in order to increase the significance so that state officials in future develop their legal conscience in fact that with regard to the fact that constitutional council norms with regard to the constitutional norms interpretation have are significant. That's what I wanted to mention.
Are there any other questions, remarks, or comments? Please. I would like to add briefly. Please go ahead. I will be very brief. I hope that we will have another seminar to discuss these questions, and hopefully we will be able to meet face to face. Well, indeed, this is more of a political question, especially when it comes to the collegial body. When it comes to parliament, the responsibility there is more of a political nature, and sometimes maybe I don't even know how to put it right. Maybe this question will mostly refer to some individual officials, especially if this is the normative act of a president or of a minister, and it's annihilated by the Constitutional Court or Council. In these cases, non-execution of the decisions may serve as a basis for impeachment. And again, we're talking about political and legal constitutional matters. Therefore, in some countries, this can be used as a ground for political and legal responsibilities. Have you finished? Thank you so much. Any other questions, remarks, comments? Dear colleagues, distinguished participants of the seminar, I think that it's high time for us to wrap up. We've listened to very interesting reports on the execution or non-execution of the decisions of the constitutional courts. We've witnessed progressive international experience, once again demonstrated by our colleagues, and this experience shows that the timely execution of the decisions is one of the main conditions for the confirmation of the principles of legal state. And we got to understand once again that the legal positions of the constitutional review bodies must be reflected either in the legislation or in its enforcement. it's necessary to develop clear mechanisms for their implementation. I think that here we need to understand one important thing. Non-execution of the decisions of the constitutional courts doubts the entire mechanism of the implementation of the provisions of the Constitution, which eventually leads to legal uncertainties, hence violation of the laws and freedoms of people embodied in the Constitution. I really hope that this discussion helped us identify our weaknesses, and hopefully we will be able to find solutions to them. I would like to thank our participants for their active contributions. I would like to especially thank our partner, particularly the Council of Europe, the European Union and the Venice Commission, as well as experts who provided their speeches today. We're also very grateful to the team of technical specialists and interpreters who made this seminar possible. I declare the work of this seminar closed. Thank you so much for your attention. See you next time. Thank you very much.
Хороших выходных всем. До свидания.
Have a great weekend. Thank you.
Отличная организация. Поздравляю.
До свидания всем. Спасибо за хорошие идеи.
Отличная организация. Молодцы. У вас, как всегда,
Спасибо.
очень хорошие мероприятия.
Спасибо большое.
Удачи.
Надеюсь увидеться снова в ближайшее время.
Хорошо.
Всем привет
Удачи.
нашим друзьям в Молдове.
Спасибо большое. Я сейчас в Бишкеке.
Бишкек, ну, заезжайте к нам.
Вот я так и сделаю. Удачи.
Лучше вы к нам.
Всего доброго.
Хорошо, до свидания. Кстати, я очень рад, что наши киргизские коллеги вернулись к идее Конституционного суда. Это правильное решение.